Okay, the first bill that we're going to be talking about, and I'm going to be closely following here now, this sheet right here that says the 2016 legislative update. The first bill pertains to short-term rentals, and this is a bill that I would call an indirect bill that pertains to associations. It's not a direct application to associations because this law pertains to city, towns, or counties and their ability to regulate short-term rentals. And so this bill is Senate Bill 1350. The gist of this bill is that a city, town, or county may not prohibit or restrict the use of or regulate, based on their classification, use, or occupancy, vacation rentals and short-term rentals. And so how did this bill come about? How do we get a law passed that says that a city, town, or county cannot prohibit or restrict vacation rentals or short-term rentals? What do we think? Airbnb, right? And vacation rental by owners. And there's a number of other new ones that are popping up now. And so what's happened is a lot of these companies are pressuring cities, towns, counties, states to pass laws that are friendly to their business. Okay, and it's kind of a win-win for both of them, because most cities, towns, and municipalities in Arizona did have a minimum 30-day rental requirement. They had a city code provision that says you cannot rent for less than 30 days, or you're considered transient housing, which would be like a hotel. And however, it became a win-win because, okay, these companies, vacation rental by owners and Airbnb, it was the block wall that they weren't able to get over, because people were turning the owners into the cities, the owners were getting fined by the cities, so they were limiting the number of short-term, less than 30-day rentals. The cities thought this was palatable because why? Tax revenue. They can get the tax revenue from these short-term rentals, so it puts more money in their coffers. And so basically that's how, in my opinion, that's how this law came into effect. There are a couple of, back doors here, and then we're going to talk about what the implication is for associations. So kind of the loopholes here are city, town, or county may regulate vacation rentals or short-term rentals for the following purposes. So there are some limited times where the city, town, or county can regulate a vacation rental. And this would be where there's the protection of the public health and safety, including rules and regulations related to fire and building codes, health and sanitation, transportation or traffic control, solid or hazardous waste, and pollution control and designation of emergency point of contact, blah, 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 blah. So, not very many times is that exception going to come into play, right? A second exception would be that the city would be able to regulate vacation rentals if they're adopting and enforcing residential use and zoning ordinances, including ordinances related to noise, protection of welfare, property maintenance, and other nuisance issues. So if they are finding that they're having some of these other issues, they would be able to go back and do some sort of regulation and enforcing zoning ordinances if any of these noise type situations would come up. And lastly, limiting or prohibiting the use of vacation rental or short-term rental for the purposes of housing sex offenders, operating or maintaining a structured sober living home, selling illegal drugs, liquor control or pornography, obscenity, nude or topless dancing, and other adult-oriented businesses. So we can prohibit vacation rentals that are doing that. And one of the really fun things about having done this for 20 years is I have some really good stories. And I have some really good stories with people that are in this room, in terms of crazy things that have happened in an association. And I have an association, a very nice association, right in Paradise Valley, where we had this exact thing happen, where people were renting this home. It was a luxury home. It was not like your typical Super Bowl weekend, but they were renting it to film pornographic films. And it was a visible property in the association. So this is kind of all out in the open. They had some sheets up and stuff, but it was quite the discussion at the association. So we have seen that that's going to be a limited exception. Okay, so bottom line is city, towns, and counties can't prohibit or regulate, restrict the use of or regulate vacation rentals and short-term rentals. How is this going to, affect associations? So let's turn to the next page, which is page 2. Okay, if you were one of those associations that was relying on your city, town, or county's ordinance to say 30-day minimum rental, and you were, telling your owners, you can't do this, you can't lease for less than 30 days because of the city, town, or county ordinance, guess what? As of January 1st, 2017, which is the effective date of this bill, you can't rely on that anymore because this law trumps all of those ordinances. So what does that mean for associations? First, I got a question right when I came in here tonight where somebody said, our association already has rental restrictions in our CC&Rs. If you have rental restrictions, this in no way changes your ability to enforce those rental restrictions. Okay, so if you have a minimum 6-month rental period in your CC&Rs, or you have a 30-day minimum rental period, or you have a prohibition against rentals period, all of those are still enforceable. This law does not affect that at all. What this law does raise questions for the associations that don't have any rental restrictions and that don't want short-term rentals in your community. Now is the time to consider doing a CC&R amendment to, limit rentals, if that's something that you want to do, if you don't want these short-term rentals. And in my experience, this vacation rental by owners type situations have really only come up where I've seen them as an issue over the past 2 to 3 years. And frankly, we haven't had that many problems. So you may want to take a wait and see approach and see how things go starting in January 2017. And if it's not a problem, then, maybe you start to allow the short-term rentals because you don't have a restriction in your CC&Rs. But I do have other associations like the pornography example, or the example where we have these people that come in for party weekends and they're trashing the pool and they're breaking glass and up all night partying. And, that's right next to a family that has little kids that have to get up to go to school the next day. And that's problematic. So, if you're in that situation right now, you really need to think, do we need to put in place a rental restriction? Now, if you're a planned community, it's significantly easier to implement a rental restriction. You just need to look at what your CC&R amendment provisions are. Typically, in a planned community, it takes somewhere between 51% and 90% to amend your CC&Rs. It's going to be specific for each set of your own CC&Rs. A condominium's a little bit different. In a condominium, there are special requirements regarding restricting rentals, and we have to look at what is the restriction that you want to put in place. If you want to do a total prohibition of rentals in a condo, you need 100% approval of the membership because it's a change in use, and under the Condominium Act, it requires 100% anytime you change the use of a condo. So that's going to be impossible. So if you come to me and ask me, I will say, I don't think that's going to be possible. You may be able to implement some rental restrictions, such as a 30-day minimum, 6-month minimum, 1-year minimum, and we can look at those options if you're, a condo or a planned community. So that is a new law that you just need to know about. It's going to be going into effect January 1st. If you're thinking about fast-tracking an amendment to your CC&Rs before that January 1st date, you really need to start working on that starting in September at the latest. Because we typically need 2 to 3 months to get the ballots out and voted on by the membership. Okay, that's number 1.